Hi, my name is Priscilla and I'm from Advantage Partnership Lawyers. Today I'll be speaking to you about international commercial arbitration. The main topics for today will be what is arbitration and what are the main characteristics of an arbitration agreement as well as the proceedings. So, arbitration is a form of alternative dispute resolution and it is a way to resolve disputes outside of the courts. Arbitration is often used for the resolution of commercial disputes, and it can either be voluntary or mandatory as per a pre-existing contractual agreement between the parties. The dispute will be decided by one or more persons, which are known as arbitrators, which will render what is known as an arbitration award. An arbitration award is legally binding on both sides and is enforceable at court. So why should you choose commercial arbitration? So for many organizations, the thought of a court procedure is quite daunting. They're known to be quite lengthy and also quite expensive. So in the case of an arbitration, many organizations choose this path because they can achieve a peaceful and amicable solution, and they can in many instances resume their business relationship. They can also keep costs down. They can also avoid losing credibility through public trials, and they can also resolve disputes as soon as possible. So the two key factors of arbitration are that you can achieve a resolution outside of the formal court procedure, and that you can achieve an effective and amicable solution for both parties, or more parties in some instances. So there are two forms of arbitration. The first is institutional arbitration, which is managed by an institution, such as the ICC, known as the International Chamber of Commerce, or ad hoc arbitration, which is managed by the parties themselves. The major international arbitration institutions include SIAC in Singapore, LCIA in the United Kingdom, AAA in the United States of America, the JCAA in Japan, the SCC in Sweden, and as I mentioned earlier, the ICC, which is a global institution and is the #1 institution for arbitration globally. The ICC just celebrated its 100-year anniversary. It was established in 1919 at the Atlantic International Trade Council, and today it is composed of companies and organizations in more than 130 countries. So the purpose of the ICC, well, the ICC was actually founded in the aftermath of World War I, when no world system of rules governed trade, investment, finance, or commercial relations. The ICC's founders acted on their conviction that the private sector is best qualified to set global standards of business. They called themselves the Merchants of Peace. So underneath the ICC sits the ICA, or the International Court of Arbitration. They are an independent body that manages dispute resolution. Their main role is the appraisal and approval of arbitral awards made by the arbitral tribunal of a proceeding. So now to the next topic for today. What are the main characteristics of arbitration? So there are four main advantages of an arbitration. That is, #1, flexibility, #2, privacy, #3, promptness and finality, and #4, international enforcement. We'll go through each one now. So the first characteristic or advantage, flexibility. What does this mean? Well, it means that the parties actually get to decide many aspects of an arbitration agreement and also of arbitration proceedings themselves. So for example, parties get to decide the arbitrator or arbitrators, the arbitration institution, the place of arbitration, the language of the arbitration, as well as the governing law. Further, parties also get to decide the deadlines and hearing dates, as well as other various steps that are involved in a proceeding. It's quite custom and tailored to each arbitration and to each organization. The second point is privacy. So what does this mean? Well, as you may know, a public civil trial is generally made public. The proceedings and the award are made public, and they're available in this day and age online. However, in an arbitration, they are generally private. The only circumstance when they may be released to the public is there's actually a few set of circumstances, and each arbitration institution has their own guidelines, but parties can apply to have them rendered confidential. So for the most part, they are private. The third point is promptness and finality. So what does this mean? This means that in most situations, there is no room for an appeal. The award that is rendered by the tribunal is final. Disputes can't actually be prolonged or delayed unduly. The parties come together, make an agreement to work together toward an amicable and quick solution. Tactics to delay or to confuse the tribunal or the other party doesn't work in an arbitration. Also, there is that opportunity to save time and money. The final point is the power of international enforcement. So the enforcement of an award is reliant on whether the country is a signatory to the New York Convention of 1959. There are currently 159 countries and regions that are members, so you're in most situations safe. However, some countries don't accept the judgment from other courts that are from foreign countries. That includes China and Thailand. So what does an arbitration cost? There are three main expenses that may be incurred in an arbitration. The first is that of the arbitrator or arbitrators, that is their fee and expenses, as well as the fee and expenses of any expert witnesses that may be called. This could include travel, meals, hotel stays, whatnot. The second is the administrative costs of the ICC or another arbitration institution. Generally, they will provide a schedule of fees up front. And third are any legal expenses that are incurred in the procedure, such as your legal counsel fees. Some points to consider. With an arbitration, the award is generally final. So you must bear in mind that it could be your only chance to resolve this dispute. Costs may be higher if the proceedings are prolonged, longer than forecasted. You also need cooperation from all the parties involved. So if the claimant or the respondent or whichever side of the proceeding is against yours in a particular arbitration are not cooperative, it can be very difficult, because at the end of the day, this is a voluntary procedure. They're not bound to contribute financially, and they're not bound to cooperation. So that can be a tricky point. As I mentioned earlier, the features of an arbitration, and in specific an arbitration agreement that parties can decide, include the number of arbitrators, the language used, the place of arbitration, the governing law, and the institution itself. Before we wrap up, many people talk about mediation as another form of alternative dispute resolution. Whilst mediation has its merits, it is quite different to an arbitration. The main difference is who makes the final decision. So in an arbitration, the arbitrators make the final decision and the parties are bound to this. In a mediation, while the mediators work with the parties toward a resolution, ultimately the parties make the final decision themselves. Again, thank you for listening. If you'd like to hear more or you have any questions, please leave us a comment or send us a message. We'll be delivering seminars in Sydney about arbitration and potentially in Japan later in the year. So stay tuned, and thank you again. See ya.